Welcome back. Now we're ready to take a look at the antitrust, intellectual property, and trade regulation cases as part of the Supreme Court's October 2010 term. I'm your host, Kelso. Well, we had only one significant trade regulation case this term, and it will be of interest really only to the communications companies and their lawyers, so I'll keep this short for the rest of you. In order to keep incumbent local phone companies, which own the phone lines that connect to your house, from extracting monopoly prices from competing telecommunications companies that need access to those lines to provide their services, the Federal Communications Commission has generally required that the incumbent local phone companies, which are referred to as local exchange carriers or LECs, make their local networks available to competitors at cost-based rates. Several years ago, the FCC issued an order slightly modifying the cost-based access rules so that LECs had to make what are called their entrance facilities available for interconnection purposes at cost-based rates, but could make their entrance facilities available for what are called backhauling services at market-based rates. Now, backhauling of data does not involve contemporaneous two-way data exchange. So the FCC has concluded that competitors don't need that service at cost-based rates to be competitive. Well, in the case before the Supreme Court this term, Talk America versus Michigan Bell Telephone, Michigan Bell took the position that under the new FCC order, they should not even have to make their entrance facilities available for interconnection purposes at cost-based rates. Well, this position seemed to be contrary to the language in the orders, and the FCC indicated that the interpretation was incorrect. Nevertheless, the Sixth Circuit agreed with Michigan Bell. The Supreme Court, deferring to the FCC, unanimously reversed the Sixth Circuit. Now, sometimes the Supreme Court lets erroneous decisions stand, since the harm from the erroneous decision is limited to the parties before the court or a small community of interests. In this case, however, I think the Sixth Circuit's error would have created competitive chaos in the telecommunications marketplace, and the Supreme Court correctly took the case and reversed. Now we turn to intellectual property, where the court issued three interesting patent decisions this year. For 220 years, the fundamental principle of patent law in the United States has been that inventors have the right to patent their inventions. Patent rights are, of course, assignable, but those rights originate with the inventor and are traceable back to the inventor. Among other things, this means that an inventor must expressly grant his rights in an invention to his employer if the employer is to obtain those rights. In other words, the employer's rights must spring from a contract with the inventor. A challenge to this basic understanding was presented to the court in Board of Trustees of Leland Stanford Junior University versus Roche Molecular Systems, where Stanford University, which had previously employed the inventor of an improved method for quantifying HIV levels in patient blood samples, brought a patent infringement action against Roche, which had received an assignment of the inventor's interest in the patent. Roche commercially exploited the patent, and its HIV test kits are used in hospitals and AIDS clinics worldwide. Stanford claimed that the Bayh-Dole Act, enacted in 1980, changed the rules with respect to federally funded research that results in patents. Stanford interpreted Bayh-Dole as vesting all patent rights in the employer to be shared on a negotiated basis with the federal agency which had provided the funding. Under this interpretation, the inventor's assignment of rights in his patent to Roche would have been void, since he would by definition have no rights to assign. Well, the Supreme Court disagreed. The court first noted that Congress had, in a few other specific areas of federally funded research, actually expressly vested title to patents in the federal agency. For example, there are laws providing that certain inventions made pursuant to contracts with NASA, quote, shall be the exclusive property of the United States, close quote. So Congress knows how to vest title in someone other than the inventor. The Bayh-Dole Act does not contain any such language clearly vesting title in the federal contractor. Instead, the Act provides that contractors may, quote, elect to retain title to any subject invention, close quote. Which means, quote, any invention of the contractor conceived or first actually reduced to practice in the performance of work under a funding agreement, close quote. Stanford argued that any invention of the contractor implicitly meant that title to its employees' inventions vested in Stanford as employer. The court was unwilling to indulge in that leap of interpretation. Instead, the court held that the phrase any invention of the contractor simply meant any invention owned by the contractor. Given this interpretation, the Bayh-Dole Act does not displace an inventor's title to his invention. Instead, it merely regulates and clarifies the priority of rights between the federal government and a federal contractor with respect to federally funded inventions that already belong to the contractor. The court's interpretation of Bayh-Dole is clearly a loss for Stanford, but I don't think it really fundamentally changes the patent market with respect to federally funded research. It is common practice for federal contractors to obtain assignments of patents from their employees. And some agencies that grant funds to federal contractors expect those contractors to obtain assignments. In fact, the National Institutes of Health, which provided the grant funding in support of the patent before the court, recommends that contractors should, quote, have in place employee agreements requiring an inventor to assign or give ownership of an invention to the organization upon acceptance of federal funds, close quote. Precisely because, in NIH's view, quote, by law, an inventor has initial ownership of an invention, close quote. So in short, Stanford has learned an important lesson the hard way. It should have read NIH's recommendations. Instead, it had to learn this from the Supreme Court. Well, our second patent case involves Section 282 of the Patent Act of 1952, which provides that, quote, a patent shall be presumed valid, and the burden of establishing invalidity of a patent or any claim thereof shall rest on the party asserting such invalidity. In Microsoft Corp. Versus I4I Limited Partnership, the court held that Section 282's invalidity defense had to be proven by clear and convincing evidence. Now, the statute does not expressly specify the standard of proof, but the court found that long-standing precedent prior to enactment of Section 282 made it clear that clear and convincing evidence was required to overcome the common law presumption of validity. Most persuasive was Justice Cardozo's opinion in the 1934 decision Radio Corporation of America versus Radio Engineering Laboratories, where the great Cardozo wrote for a unanimous court that, quote, there is a presumption of validity, a presumption not to be overthrown except by clear and cogent evidence, close quote. Well, according to the court in this term's decision, when Congress used the phrase in the statute, presumed valid, it brought with it into Section 282 the long-standing rule that the presumption could be overcome only by clear and convincing evidence. Finally, in Global Tech Appliances versus SEB, the court held that to establish a claim for induced patent infringement under Section 271B of Title 35, the plaintiff must show that the defendant had actual knowledge that the induced acts constitute patent infringement. This means the defendant must either know the patent exists and that the induced acts will infringe the patent, or that the defendant was willfully blind as to both the patent's existence and the infringement, which, drawing upon the criminal law, is the equivalent of having actual knowledge. It is not enough to have acted unreasonably, or even to have acted with deliberate indifference to a known risk. Those lesser forms of culpability do not satisfy the statutory language which requires actively inducing infringement of a patent. Well, that's it for the antitrust, intellectual property, and trade regulation cases for this term. So to continue your review of the Supreme Court, click on the Civil Procedure link in your Supreme Court Review table of contents.